Hi everybody, Andrew Cherin, attorney at law. I'm a Seattle personal injury lawyer, and today I want to talk to you about negligent entrustment. What does that mean? We've heard that phrase around, but what does it actually mean in relation to a car accident injury case? Well, negligent entrustment is a legal liability term which basically comes into play in a few scenarios, but most likely in a situation where a policyholder of an insurance policyholder, so the person that owns an insurance policy of a car, most likely owns a car too, lets someone else drive their car that's not on the policy and is probably not in relation to them, but probably shouldn't be driving in some way or another because of some reason. Maybe they have no driver's license and the person knows it, um, etc. It could be a number of different things, which causes liability to be pointed back at the person who let this person drive who had no reason to drive. So a couple situations apply to that. So one I can think of is letting a child drive, or someone who doesn't have a license, maybe related to them, that's younger than them. So let's say 12-year-old, the policyholder lets their 12-year-old son drive their car, and the 12-year-old son, rear ends somebody and injures them in a car accident. Because normally they'd be able to go after that 12-year-old son. I mean, ideally here though, you're still going after the parent anyways for negligent entrustment, or some kind of liability that points to them because they're the responsible adult who's responsible for their child. But a situation where that could come into play where it's non-relation is, let's say the owner lets a 12-year-old friend's son drive. So, or a 12-year-old, the 12-year-old, the son, the 12-year-old lets the friend drive of the 12-year-old who's also 12 as well. So that 12-year-old gets in a car accident, they're not related to him. The dad knows that the 12-year-old shouldn't be driving, they don't have a license. That situation, that 12-year-old's dad's not going to be liable, or that 12-year-old's parents isn't going to be liable for the boneheaded mistake of letting their son drive by the friend's parents. So the policyholder will be liable in that situation. Another situation is intoxication. So let's say you're the DD, but you, for whatever reason, let your drunk friend drive, and they shouldn't be driving your car because they're obviously intoxicated. In that situation, you're liable because even though maybe they had their own insurance, they're liable too. But in this situation, your insurance could be liable as well because you let this obviously intoxicated driver drive your car, so you would be liable for that situation. Or if someone doesn't have a valid license, that they shouldn't be driving, it's your friend, they're of age to drive, but they don't have a valid license, and that, then you're going to be liable for that situation as well, and your insurance is going to cover that. Another situation could be, that this person has ability or they not ability, but they have this proclivity to drive really fast, and they've been in a ton of accidents before, and it's highly dangerous. Their license was suspended, same situation, but they get in another car accident, and you knew that they were in danger of getting a car accident. This is kind of a stretch, but this situation could come into play for negligent entrustment, and then you'd be liable for that situation. It's kind of rare that this situation comes up, negligent entrustment, but it does come up. So if you are injured in a car accident and you think the insurance companies are pointing to different people involved, who's at fault here, you need to get a Seattle personal injury lawyer involved. I give free consultations. My number is 206-850-6716. And if you want to learn more about personal injury law, visit my website, www.lawcherin.com. There's a lot of great videos on all things personal injury.